please join me in welcoming Tara Morgan.
Oh, thank you very much, and thank you for having us. I was telling somebody earlier, I've spoken at M&L conferences, I think once before, as a provincial conference, but I've had the pleasure to speak at a couple of regional conferences, and it's always a good crowd, and there's always great discussion. So we're pretty happy and pleased that we were invited to come this year. I think the last time I spoke was 2019. Myself and a couple of colleagues were at the conference out in St. John's. So for some of you, this might be a little bit of a repeat of some of that information, but of course, councils change, people change and positions. And so we thought it was important to kind of share just some of the information. But like Mayor Farrell said, there are some hot off the press things too. I'm not going to let any cats out of bags, but certainly we can talk about some of the things that are happening kind of live right now with Crown Lands. So before I start, I just want to introduce myself. So my name is Tara Morgan. I'm the director responsible for the Crown Lands division across the province. But with me today, I have Roger Primer. If you guys just want to give a wave or stand up, Roger Primer. Roger is the manager of the Central Regional Lands Office. With him is Trevor Mills, a land management specialist with also our Central Regional Lands Office, and Jonathan Blackler, who is land management officer with our Central Regional Lands Office here in Gander. So we're going to be around most of the day. So if you have questions or you want to kind of pull us aside, even if it's not central related, these guys are a wealth of knowledge on process and that sort of thing. I'll be around until about 2, and then I've got to leave to get somewhere else for another meeting. But these folks will be here all day. And certainly if you have questions after this or want to talk about specific files and that sort of thing, our offices are always available and open to discuss. So let me find my... So like I said, I do, I guess, realize that I'm between you and lunch. Hopefully this won't be too difficult, but I know it's an important topic. So anyway, we'll get through it. So what I thought that I would do is just give an overview of the process, our application process. A lot of people are often surprised when they kind of see how an application happens through Crown Lands and kind of the many steps that it takes to get there. Some of the improvements we've made. I'd like to talk about some things that are specific to municipalities, some questions that we've had, some tools that we have that assist municipalities' policies and that sort of thing, specifically Section 201 of the Municipalities Act, the Municipal Leasing Policy, and the reserve policy. And then I'd also like to talk, and this was kind of newly added this week, so anybody that's listened to the news, I guess since last fall especially, there's been a lot of talk about squatters' rights in Crown Lands. Section 36 with Crown Lands. It's been in the media. It's in the media this week. So we thought that this was a good opportunity with such a crowd, such an audience, to kind of shed a little bit of light on what this beast of Section 36 is and what it means and some of the limitations and challenges that we kind of experience with it. And then, of course, hopefully there's questions. Like I said, if we can't get to the questions, Roger, Trevor, Jonathan, and I are here for most of the day. Okay. So no questions yet, so that's good. All right. So I guess let's just start. What is Crown Lands? So Crown Lands is a resource. It's a resource of the people of the province. It's not owned by government, but it's managed and allocated by government. And it's important. It's important to everybody. It's important to municipalities. It's important to individuals. It's important to business. It's needed for economic growth. Business economics rely on land, agricultural industry, forestry industry, tourism industry, general business, new opportunities. I mean, there's land components to everything. So it's important and it's a resource. It's important to residents who enjoy the outdoors. We're a people of the water. We're a people of the forest. We like our hiking and camping and we like generally getting outdoors. It's our culture. It's who we are. So land and availability and to access lands is very important in that regard. In some places you go, there's not a ton of Crown Lands and access can be has to be bought or it's a little bit more tricky to navigate. We're very fortunate here that we have an abundance of Crown Lands to get out and do the things that we like to do. It's important for environment, social sustainability reasons. We need to protect our natural areas. We need to protect our resources and we need to protect the land base. And we need to protect it not just for ourselves, but for our future generations, because we know what we have and we want others, of course, to have it kind of down the road, whether it's for economic or recreational purposes too. And then, of course, it also generates revenue for the province. So we have leases, licenses, easement policies that generate revenue. I think it's around $4 million a year. that come into the province for, I guess, activities related to Crown lands and there's also grants. So we sell land as well. So often revenue for sales, and that isn't and you'll kind of see it when I go through the process. It's not like going into the grocery store and buying a loaf of bread and you come out with your land and government gets their money. There's a bit of a process to go through. So revenue generation sometimes is a little bit delayed, but there's definitely a big part of what we do generates revenue for the province. So Crown lands are administered and controlled by the Minister of Forestry, Fisheries, Forestry and Agriculture. So Minister Bragg is our minister. And of course, I don't want everybody calling, certainly, I mean, you can, but things are delegated. So when I say the minister is responsible for Crown lands, there's all kinds of delegations in place. So nobody tell him that I said he is, everybody's supposed to call him. Don't send your applications to him, send it to the Crown Lands info line. If you have a question about status of an application, give us a call first, please. So, but they are administered under the Lands Act. Responsible ministers, the minister responsible for fisheries, forestry, and agriculture. And we have a crazy amount of Crown lands here. Like we are up there with the percent of Crown lands with BC, Ontario, Alberta. A significant portion of our lands are Crown managed or Crown allocated. It's about 88% of our province's land. So, I mean, it's not a small piece of property when you consider the challenges and the effort that municipalities take in managing kind of their land bases. And of course, they have many more responsibilities than kind of what we do. But it's a big file and it's a big area to manage and kind of figure out, kind of especially in our system, which I'll get into. So managing Crown lands would definitely be a lot more easier if we knew where the heck this stuff was. And we don't. So past legislation and our province's long history has created some challenges for us. And I'll get into some of that a little bit more, but in a lot of cases, there's poorly documented land transactions, which complicates land matters in Newfoundland and Labrador. And of course, there's no mandatory requirement to register land. So there's a significant amount of private land out there that we don't know necessarily that it is private. So one of the things that I guess we struggle with when we get applications for Crown lands is trying to first determine whether or not we can actually take the application if the land is Crown or not. So I will get into section 36 a little bit later on, or squatters' rights, but I guess in this part, I just wanted to kind of talk about a regular application that goes through and kind of what the process is. But often we get, I guess, frustrations kind of aimed that process takes too long. I don't know what's taking it so long. And I'll show you what our process is. But one of the first thing, and I guess this is where we're looking for a little bit of support or I guess at least, sharing of information, is that it's the applicant's responsibility to complete the research to kind of make sure that they have a good application. We often get applications, honestly. We've had maps where it's just a line and it says road and a square. And we're kind of like, okay, well, where is this? And then the coordinates information is missing. So in order for us to process an application, we need an application to process. And given kind of the environment that we work in, it is the applicant's responsibility to kind of provide that information to us. So sometimes I guess we hear applications being in the system for 2 years and nothing's been kind of heard back. And when we go look it up, we're like, oh my gosh, that's awful. Of course it's awful. And then we go and look and maybe the application wasn't complete. Not saying it in all cases, we're definitely guilty of taking too long in some processes. But to get an application through the system as quickly as possible, we need to start with a good application. So one of the things that I guess municipalities can assist applicants with is I guess sharing information on whether or not land, I guess there are other interests in that land. Sometimes we'll get an application and it'll be 3/4 of the way through the process and then somebody will come out of the woods and say, wait, now that's Jim's land or Brown's land or something. And of course, then that complicates things and we have to go back and kind of do some more research. So there is information available. It's out there. We recommend that applicants talk to their municipality. They talk to their neighbors before applying for Crown land, especially in municipalities. Looking for fences, old building foundations, that sort of thing on the property. When you apply for Crown lands, there is a tick box that asks whether or not you've been to the property. So the expectation is that you've walked the land, you've looked at the land, You've done a little bit of research, talking to municipalities to see whether or not there's taxes being paid on the land. We do fairly often get applications where somebody will apply for land and then somebody else will come in when they see the sign go up and say, wait, I've been paying taxes on that land forever. So those are things that, I mean, really could be straightened out before the application gets to us. So there's also like registry of deeds, regional crown lands offices, land use atlas. There's all kinds of ways that we can, I guess, make the application process a little bit easier. So our applications are first come, first served. However, there are some priorities. So right now, wind, for example, in the province is a priority. I probably should have put a couple of slides about wind development here in the deck, but not that I forgot about it. Right now, the process is with IET, so it hasn't reached the Crown Lands process, but I'd be certainly happy to talk about wind if people have questions and that sort of thing. But agriculture files get priority, utility companies, applications from municipalities specifically get priority, and some commercial development applications, depending on the size and kind of what they're for, get priority. But of course, our intention is to put everything through the system as quickly and efficiently as we can. So one of the changes, I guess, that we recently made, and I don't know how often folks visit our website, but we recently went through a considerable effort to update our website with the goal of making things easier to find. So I guess just for knowledge, similar, no change in our application fee. It's $150 plus HST, so $172.50 is the fee. They're non-refundable. They've always been non-refundable, but just reminding folks that they are non-refundable. And old forms, we don't get them as much, but I think there's still old application forms kicking around some law offices, possibly some municipalities. But we do have an updated form. And the forms are updated with things like an email address. Imagine that, multiple applicants being able to I guess, apply for land, having a designate kind of indicated on your application. So if you haven't updated your forms, if you have forms available at your municipalities, I would suggest that you go to our website and download the most up-to-date form, because we have had, like I said, it's not as much anymore, but we do have to return the application if it's not completed on the most up-to-date form. So some of the past changes or some of the changes that we've made, probably they may have been since 2019, but I think most of them were probably in place in 2019. Like I said, email address, we've improved the selection options. There is an online payment ability now that didn't exist in the past. We have, of course, the new website, clear information. And when I say clear information, so you can go on the website if you're looking to apply for a residence or a boathouse. You can select on the first page if you're looking for personal use or commercial use or government use, which would include a municipal application. And then kind of as you click through, it'll prompt you to kind of, well, what exactly are you looking for? And then as you select these options, other information will pop up. When you go to apply for the actual land, there's, and I know it's hard to see, I've got the link at kind of the last page, but when you get to kind of the last page, even how to apply for the land, it's broken down, it's more easily understood and read. So our hope is to provide better information, clearer information on our website and easily accessible. I will ask if municipalities do have, I guess if you're getting asked questions and you're like, oh, why am I answering this again? It's a Crown Lands question. And you think that there's a button or a link or a frequently asked questions component that we could add to our website to make your lives easier, we're certainly open and available to that. We do have, I guess, on our website, the ability to book appointments with lands offices. So I would think municipalities are a little bit different. We definitely value the relationship that we have with municipalities. And if a municipality needs an audience with the office, I wouldn't suggest that you guys specifically go through an online booking appointment. I think most municipalities have a pretty direct line to the regional offices. But we did introduce a appointment system before the pandemic. I guess 3 years is a long time, and often it's thought that that this was introduced as part of the pandemic, but we actually moved to an appointment-based system to better serve our clients about 6 months before the pandemic had started. So just a quick review of our application process. So like I said, it is first come, first served. And I apologize if I'm speaking fast. I know I'm trying to get you to lunch and I'm trying to get you to a point that you have an opportunity for questions. So I guess our application process, like I said, it is first come, first served. There are fees associated. The fees are non-refundable. And I guess one of the biggest criticisms I think that people see or frustrations to Crown Lands is the time it takes to get an application through the system. And we receive a lot of applications. So in 2022, we received 3,100 applications for Crown Lands. It was a little bit less in 2021 and 2020. We think that was because of the pandemic, but in 2019, it was about 3,000, almost on the button actually. So when we get applications, where like if you purchase land from a neighbor, you're buying a house, you're taking that risk on, can I build a shed where I want to build a shed? Am I going to meet the zoning requirements? Am I going to be able to do what I want to do? When you purchase land or acquire land from the Crown, there's an extra level of due diligence that we feel has to apply. It's a legal land transaction, of course, but it's heightened by the responsibility of government to ensure usability. So we will not or cannot, should not issue title to somebody if they can't use it for what they want to use it for. So often applicants will say, why do I need to give you all this information? And the information is required so that when we send it to our municipalities, our other government agencies for their input, that they have an understanding of what's being applied for and can provide the best answer back. So this is our process. So basically applications come in through the top left corner there. So somebody goes in online, they pay their fee, or they call central cash and make the fee paid there. And then they email a copy of their application with proof of payment to us. So we'll take the application, and folks in Roger's office and Steve Barnwell and Jeff Bannister's office in our other regions will take the application and they'll look at it and they'll start that analysis. Is it complete? Do I have a map? Do I know where the location is? Is this something that can be applied for? If there's information required, they'll go back to the applicant and they'll say, hey, can you give us this? Most of the times they know at that point if there's anything missing, but sometimes missing information does creep in later on in the process and we may have to go back, but we do our best to try to get a fully complete application. Once we get the application, we'll look at it and we'll say, hey, it's in a municipality. So once we realize it's in a municipality, we'll send it to the municipality. We'll also send it to municipal and provincial affairs, land use planning. We'll send it to environmental assessment to see if it triggers an environmental assessment. We'll send it to Service NL to see what is it in a protected roads area. So we'll ship it out to all these other agencies for comment and consideration because they'll provide information back on whether or not another kind of permit is required. Is this what the person wants to do? Allowable or doable given the context? Is an environmental assessment required? So we do ask agencies to get back to us within 21 days so that we can get back to the applicant within our 90 business day service standard. Sometimes that's not possible. Anybody that's familiar with the environmental assessment process, for example, there's a legislative 42-day review period as part of that. So while we ask for 21 days, we do know that there are cases where that's not possible because of other legislation or because of legislative considerations. For example, if TI needs to look at our transportation infrastructure, say it's an access road, and they need to go out and look and see, is it safe? Is it safe to access the highway from this point? Perhaps it takes them a week or so to get to the site, and then by the time they kind of collect their information, they could potentially be over the 21 days. So we won't necessarily move an application after the 21 days, but we definitely do follow up with the referral agencies and ask them to kind of get back to us. And there are some cases where the referral agency will actually contact the applicant as well and get information. So once we get all the information back, we will look to make a decision on the application. So the decision can be approved and then it moves on to the next phase. It could be refused, at which point it is refused and the file is closed. The applicant may have decided to withdraw. That's a decision point too, or the applicant may have decided to cancel by either calling us and telling us that they canceled their application or by not providing information that we required and had asked for. So that decision block, that's where we are aiming to get a 90 business day service standard because there's processes after that that are totally on the applicant's side with regards to getting a survey. They have up to 18 months to do that. Then when we send title documents, there's 180 days potentially that could be gone there. So when we talk about our 90 business day service standard, is to get to a decision. So our service standard was announced in 2018. And at that time, it's still only for routine applications. So routine applications are ones that wouldn't need environmental assessment. They wouldn't need zoning changes. They wouldn't need protected roads application. They definitely wouldn't be a section 36 application. So our goal was to get routine applications through the system within 90 days. In 2018, all applications, regardless if they were routine or not, 24% of all applications were meeting our 90-day service standard to a decision. In 2022, 65% of our applications are meeting that 90 business day service standard. So you can definitely see that we are improving. So I guess 2018, it was 24%, 2019, it was 31%, 2020, 37%, 2021, 53%. And then, like I said, 2022 was 65%. So when we send out when we register the application, we will send the applicant a list of referral agencies and the contact information for those agencies. And certainly applicants are invited to reach out to those agencies to check in, see the status, find out if there's any information that's required. So I guess out of all of this, I mean, definitely, I don't want to take the responsibility off of our division for making decisions on Crown lands. But in some cases, we're just not able to approve an application because it doesn't comply with municipal zoning. It didn't go through an environmental assessment process. It's not safe to access the site from the road. In a lot of cases, there's processes that an applicant can go through to kind of rectify some of these challenges. But in a lot of cases, sometimes Crown Lands is the messenger. And I ask that you not shoot the lovely people in our regional office as messengers. So we're constantly working towards improving how we do things. And I think how fast we're getting applications through the system, we're definitely not perfect. But we are definitely kind of making steps to improve things. We're trying to modernize processes, looking at more electronic processes, digitization of more things, having things show up on land use outlets better and easier to see, creating inefficiencies, whether it's through delegation, different responsibility, allocating different responsibilities and within the department, and communicating and kind of this continuous improvement process. So since 2018, which a lot of you are probably already aware, we've introduced a inquiries line. So there's a 1-800 or 1833 dedicated toll-free number for Crown Lands. There is sometimes a little bit of a wait because we get over 10,000, over 37,000 calls just to that a year. And we've got 3 positions that are answering those phones. So we will get to you. Most calls do get, if a message is left, they're getting answered same day or the next day. But there's also the best way to get to us is our email, crownlandsinfo, lands with an S at gov.nl.ca. Within the department, we have hiring priority for Crown Lands. We do have a fairly high turnover, and I think not unlike a lot of businesses, especially since COVID, and a lot of companies finding qualified and skilled individuals is sometimes challenging. But we definitely have a hiring priority within our department that definitely helps us. Like I said, we have the land use atlas. We can walk through that if anybody has questions. We have a laptop here with us afterwards that helps with some of the mapping and kind of identifying land. Like I said, we're making changes to improve communication. Like I said, I can't let too many cats out of the bag, but we are working towards a fully electronic end-to-end system. This is not a system that's going to be in place next year or even probably the year after, but there are changes that are coming that are, I guess, aiming for this kind of fully electronic system where departments can speak to each other with the same system and kind of not work in so many silos. And of course, we're always looking at our policies, procedures, and legal and legislative process as well, and trying to make efficiencies there. And then improvements as well we're working on with regards to compliance and enforcement. So that's our process. So now just specific to municipalities, this isn't really my slide, but it is something that I guess is important, and I guess we should pass along to municipalities, especially when municipalities are applying for land specifically. We have had a fair number of cases. I don't think it's so much anymore. I think municipal and provincial affairs have been doing a really good job in kind of getting their message out as well. But it used to be fairly common where we would take an application from a municipality and it would kind of get approved by us, but then when we would be stuck in this limbo waiting for additional approvals. So under the Municipalities Act, which of course is not administered under our department, there is a requirement for that minister, so Minister Howell, and again, delegated through her department, to approve certain things. So under section 201, if you're not familiar with the Municipalities Act and specifically this section, I would encourage you to reach out to the folks at Municipal and Provincial Affairs and kind of understand it, because there is a process, an extra step process that you will need to go through if you're acquiring land for economic development, or if you're acquiring land and holding it with the municipality if it's not for like a non-economic development type thing. And there's information that they require. And for section 201, which deals with basically municipalities holding real property, they need to know the purpose of the need. They need to know different things as to, I guess, conflict with other pieces of legislation and sections of legislation in there. So I don't want to speak too much because that's outside of my wheelhouse for sure. But the folks with Municipal and Provincial Affairs, just I guess a reminder, if you guys need land and it's for economic development, if it's land at all and it's valued at more than $500, section 201(2) also talks about having approval. So often municipalities, we see the best success when the municipalities come to us at the same time that they go to Municipal and Provincial Affairs. And then we try to line our processes up so that everybody's approvals and everything come out at the one time. So there's also a municipal leasing policy, and this was introduced in 2015, I think. It may have been 16. But basically, where a municipality requires land for economic development. So we all likely know that under Section 9 of the Lands Act, municipalities can acquire land for non-economic development for free. There's administrative fees, but the land is essentially free. But when the municipality wants to use land for economic development, we do have a leasing policy. It's not a new policy, but I'm always surprised when I talk to municipalities about how much maybe it's not, there's the awareness just isn't there that it's there. So it's an application that goes through a regular process, and the decision as to how you want to handle it doesn't have to happen until after the approval. But basically, as you know, municipalities are subject to market value, but with this leasing policy, you don't have to pay it up front. So if you want a piece of land, say for industrial, potentially you could apply to us, acquire the land, we would assess it at market value today. And then instead of selling it to you where we would require the payment today, you could hold it in a lease for up to 10 years. And the reason that this was put in place was to try to, I guess, allow municipalities the better chance to plan. So there were no surprises. So you know on year one that you have access to this land for the next 10 years, you know what the price is, and then it's up to you how you manage it. So we could entertain a payment fee where you make equal payments over 10 years, and we can negotiate what those payments are. You can give us 50% up front, and then we'll kind of negotiate kind of what the rest of our, but our most popular option is this lease to own kind of 10 year where you actually don't pay us anything until you realize value in it. So some municipalities have taken us up on this. And most of the time, I think it has been for industrial parks. They'll acquire the larger chunk of land, we'll give the value, and then they'll hold it in a lease, and they actually won't pay until they find someone to sell it to, at which point they know how much they have to pay the Crown. So if they sell 10% of that property, we would ask for 10% of that market value, and then continue the lease for the rest of it for the remaining 10 years. So I know it may, if this is the first time you guys are hearing of this, it may be, I'm hoping I'm explaining it a little bit easy, but it's basically aimed at locking in prices for up to 10 years and allowing municipalities more flexibility with regards to planning and being able to secure land. So if that's something that you're interested in, by all means, give us a call. We can circulate the policy if needed. But the municipalities that have taken advantage of it seem to come back and repeatedly take advantage of it. We also have an ability within existing, and this one is, I think we've had this has been around for a while. But municipalities have an opportunity, or I guess an advantage to a lot of other places where municipalities can apply for a 5-year reserve on land. So if the municipality isn't quite sure where they want to go with regards to their planning, they don't really have any immediate plans, but they know they want to kind of consider something. You can request a 5-year reserve on Crown lands within your municipal boundary. And only applications, the reserve is in place, only applications from the municipality can be accepted within there. So the municipality will basically have full control over what Crown lands applications can and can't be accepted within their town. The application would come through a normal, like we don't have an application for a reserve. We use our regular Crown lands application, but we need a map. We need to know the purpose. We need to know the location of roads if you're proposing roads. And that if you are proposing roads, just confirmation that the municipality is going to kind of take those in the roads envelope afterwards. So it allows municipalities to plan development and plan potentially in phases. There's no limit to how much land you can reserve, but we do need a purpose. You can't just say we want to reserve everything because that's not fair, I guess, with regards to allocation to other folks. But where a municipality can demonstrate a need, we're definitely here to help facilitate that process. So how am I doing for time? So we got 20 minutes. So hopefully we'll be able to get through and have some questions too. So section 36, I'm half terrified and half excited to be talking about this today. So section 36 for squatters' rights, that has been in the media quite a bit. And like I said, we thought this was a good opportunity, given the attention that it's been given, to kind of provide a little bit of information, maybe clarify for anybody that is a bit confused, because it's not an easy concept to understand, kind of what it is, how we process applications, and then talk about the recent consultation and potential next steps. So this is a piece of legislation that is in existence. This is section 36 of our Lands Act. I expect it's probably not super easy to read because it is a pretty big section. So basically, without reading it word for word, it says that so let me back up. So this piece of legislation was introduced in 1976. So it is not a new piece of legislation. It's over 40 years old. So it basically says that, and the title of it is Adverse Possession Abolished, and adverse possession and the term squatters' rights are essentially the same thing. So anytime I say adverse possession, feel free to pop in squatters' rights if it's easier. That's a more common term. So basically in 1976, the law changed, and it was an incredible change to the law. So Newfoundland and Labrador, we are an interesting case study in land titles. We have a history of squatting. So as everybody knows, we were a colony. We were managed from afar. There were actually laws in place in the 1800s and earlier that outlawed the ownership of land in the colonies in Newfoundland and Labrador. And then kind of the laws later changed that some ownership was allowed, but only if it supported the economic development and thriving of the mother nation or Britain. So we weren't really allowed to be here, apparently. And when we were really restricted on where we could go. So people settled, people came, they might have been supposed to settle in one place, but they decided, nope, I like the sunny West Coast better than the rain drizzly East Coast, or maybe they like rain and drizzle and they stayed in St. John's. So anyway, we basically have a history of squatting. And then settlers came, like I said, they may not have gone where they were intended. Everything was managed overseas. Eventually it got managed by district courts, but those district courts weren't everywhere. So, I mean, we're a crafty bunch of people, and if we can't make something work in one place, we'll make it work in another place. So you can see kind of very easily how land ownership and claims kind of probably very quickly got out of hand. And then on top of that, there were other transfers. So we had large tracts of land that were transferred, reed lots were transferred, Bowater lands were transferred, there were bond blocks that were transferred, and then not only transferred, but transferred multiple times. So they might have been transferred out of the province's purse, brought back into the province's purse, minus anything that was sold. But the challenge is that there was no, you didn't have to register it. So all these transactions could take place and very legally could take place. Land claims could happen, but nobody had to register it. Everybody was keeping their own documentation. So this is kind of where challenges kind of start. I mean, you can start to kind of see how problematic that might be, especially over such a large land base. So in 1976, it was realized that this was a problem. So the government at the time decided to introduce this piece of legislation, which basically says there's no more squatting on land. So forget about trying to claim lands in the future. It's done. Like, we're going to end it. So no period of possession for Crown lands after December 31st, 1976. So at the end of the year, 1976, there was no more squatting. But if you occupied the land openly, notoriously, exclusively, and continuously for 20 years immediately prior to 1977, we'll recognize your claim. So anybody that had been on the land prior to 56, which was the beginning of the 20-year period, and had left, you were outside that 20 period. So if you didn't already have good title, and I'll explain a little bit that in a second, you were a little bit out of luck because you hadn't met that 20-year period. So like I said, it changed in 76. Prior to that, the legislation was that you could claim land if you were basically on the land for a 60-year period. So on top of all of this settlers process, historical squatting, these land changes, we also had legislation that said if you owned land or felt you owned land, you could own it for, be on it for 60 years and claim it. But again, you didn't have to register it. So people were just keeping this documentation kind of in their, under their mattress or in the walls of their house, where people put documentation in the 1800s, early 1900s. Certainly, a lot of it was not registered with Registry of Deeds. So I guess in 1976, when squatters or adverse possession was abolished, I think the assumption was that people would come forward and register their land either with the Crown and try to get what's kind of called as good title. This piece of legislation wasn't just dropped and kind of walked away from twice, and then a third, twice it's been to the appeal, Newfoundland Labrador Supreme Court of Appeal and debated, and both times this stuck as being law, once in 1982 and once in 2013. And there was a recent case just last year that kind of brought some of the same principles forward. And again, this piece of legislation was kind of upheld. I believe that case may be going to appeal now. It's not against the Crown, and it's not, I guess, specific to a specific application. It's more of kind of a principle review on color of title, and I won't get into that. But basically, Section 36 has been upheld by the Court of Appeal. In 2023, we still receive requests. So some of the challenges that we have is people have been on land for a long time. They built their house in 1980. They've been on the land. They bought the land from somebody else when they built their house in 1980. And then in 2023, they're going to settle estates. They're going to sell their land. And we're seeing more often than not that purchasers' lawyers are coming and saying, well, we want good title. So the person might have bought it in 1980 and thought everything was perfect. And possibly there have been other transactions in between that time. But in 2023, buyers and lawyers are insisting on what's good title or clear title, which basically is title rooted from the Crown. So if you don't have that, then there's a process you have to go through. But of course, when you look at legislation, squatting was illegal or made illegal in 1976. And this is what we're kind of held to. So outside of that 20-year period, not only did you have to occupy, sorry, I couldn't hear what you said. Oh, sorry. Oh, okay, perfect. Thanks. That's a bit better. Okay, perfect. So like I said, we have cases where people purchased their land in 1980, but built their house and then come to us in 2023 and say, hey, let's settle my title. I want to sell it. My lawyer says I need this thing called good title. Apparently I don't have Crown title. And then we look, and when we look at what the possession period that they've occupied the land, and even the people before, it doesn't meet this test. So we're not able by law to do anything with it. So the option then is that the person can go through a regular process, acquire the land, but then comes in, they have to pay for the land. Well, they already paid for it in 1980. So you can see how problematic and challenging this can be, especially when you're trying to explain to somebody that land, yes, you own the land, but maybe you don't own the land. And certainly, I just want to raise too that we are not in the business of going and knocking on doors and kicking people out of their land or out of their houses that they've occupied for long times. But again, when people go to settle estates and are looking to sell land, often it's coming up more and more that purchasers' lawyers are insisting on this title. And when you come to us and ask us to give you good title, this is the piece of legislation that we have to rely on. And unfortunately, if the land doesn't meet that 20-year period, and I'll show you an example of that in a second. I just want to reiterate too, though, that Crown lands and deeds registration are often talked about and discussed and often even understood as being one system, but they are separate. So each of us operates under our own pieces of legislation. The Registry of Deeds operates under the Registry of Deeds Act that basically governs how deeds are registered, but it's a deeds registration system. It's not a title system. So it's basically, I guess, a filing cabinet of land transactions. It's not a guarantee of ownership like it is in some other jurisdictions. Some other jurisdictions have what they call a titles-based system as opposed to a deeds-based system, where once something is registered, it's guaranteed. So here you often hear people having to do title searches, and the title searches will give you a list of kind of the land came from this person in 1920 to this person in 1930, and it'll go right up through the history. In a Torrens-based system or a titles-based system, you only have to go to the Registry of Deeds, because only land that is guaranteed to be owned by you can be registered in that system. So that is not Crown Lands jurisdiction. Often the two are talked, I guess, a bit like kind of in the same context. But I think it's important to note that it is two totally different systems, and it's not mandatory in this province to register land transactions. And it's not guaranteed that land that is registered in the Registry of Deeds system, that's the actual ownership. So you can see, I hope you can see how challenging then it can be when somebody doesn't have good title based on possession. It's not registered. It may be registered, but it's likely not registered to determine how they acquired it and confirm title and why purchasers, lawyers potentially could be concerned. But again, we're not knocking on doors and kicking folks out, but it is definitely a challenge for us. So this is an interesting article. You definitely probably cannot see it. But this was an article from June 1st posted in the Telegram when the legislation was debated in the House shortly after. So the legislation was debated in the spring of 1976 and came into law in 1976 for the 1st of January. It received all party support. So everybody agreed that this was a good thing. People, and these are some quotes from the Hansard, so from the debate and from the article, persons not qualifying under the bill will have to go through the normal procedure of making applications in order to acquire Crown lands. This was a revolutionary change. It was a good step forward. It was the end of an era. It was the right and proper thing to do to end squatters' rights. It was excellent and it was an improvement. So their intentions were really good. I guess it could be said that potentially the legislation didn't go far enough, but squatters' rights, except within that narrow 20-year period, was abolished in 1976. So I just want to give you some examples. I don't know, in the back, can you see the red lines or red squares? Just barely. I don't know if there's a pointer on this thing. I don't think. So there's 3 photos up here. So when we get an application for Section 36, or when somebody comes to us, we'll ask for the history. So we'll say, well, when was the land occupied? Provide us whatever documentation you can. We'll accept affidavits, we'll accept tax receipts, we'll accept just a story. Often there's registered deeds that are also attached. But what we're really looking for, so forget all the other stuff that comes in with it. we're really looking for that open, notorious, exclusive, and continuous use for the 20-year period. So we have access. It's not every year. We don't have access to photos from every single year for every part of the province, but most parts of the province, we have access to photos from the 40s, the 50s, the 60s, and the 70s. So in this example, and it is in a municipality, I won't say which one. It is a real example of a recent application that came in. The application came in and they said that their family was on the land, lived on the land, cut wood on the land, and fenced the land up until 1940. The family had moved away, I think in 1942, and had lived elsewhere. And now in 2023, the person or a family member is coming to claim their family's land, and they asked for good title under section 36. So of course, when we look at the 51 photography, so in that case, they didn't have any wills. There was no bills of sale. It was just in the family. It was family land. There was no, it was within a municipality, but there was no municipal taxes paid on the property. And when we look at the first photo, we didn't see anything. It's treed. And what we'll do as well as, I mean, we're just not arbitrarily drawing squares on maps. There's a GIS or geographic information system exercise where we'll plot the land and kind of through the use of the GIS system, we'll transcribe or transpose the exact block. So we know we're looking at the right area in the same area. So in 1951, there was no development there. In 1966, again, there was no development. I think in 1951, you can see a little bit of a trail through the back of the property, but no development. And in 1977, there was no development. So throughout that entire 20-year period, if there was development, say in 1956, we would expect to see some clearing in the 60s photo. But there's nothing there. And even the development that was claimed to have had happened, the residents, the small farm fields, the gardens, if that was vacated in the 40s, potentially we would see some evidence even in the 51 photography that existed in the past, although it's maybe grown in a little bit. So in this case, we could not approve a section 36 or a squatter's claim for this person. Instead, what we did is we offered them to purchase the land at market value, which they weren't too pleased about, but I believe they did in the end. So this is another example. So in this case, we had photography from 51, 66, and 78. This one again is in a municipality. I hope the red blocks are a little bit clearer here. In this case, the person provided us with historical bills of sale. The property had transferred hands multiple times. Every transfer involved a lawyer, which is not something that especially older transactions had. And all of the lawyer's documentation was there. There were multiple surveys over different years that the person provided us in their documentation as well. And then when we looked at the photos, you can clearly see that in 1951, the area was developed. Now, I say clearly, I recognize that you guys are looking at this on a screen that's blown up and shrunk and all that sort of thing. But our folks do have the ability, if required, to look at these images in stereo. So if you look at something in stereo, you'll see like fence lines pop up, trees pop up. It involves using two stereo pairs, two different photos side by side. And you can kind of trick your eyes into kind of seeing things lift off the paper. But even outside of stereo, when you're actually looking at the photo, you can easily see that there was fields there were pastures there were buildings there. And again, that existed in 1966 and again in 1978. And when you looked at the photos and you read their story or their summary of their history, you could easily see that they said, oh, there was a building built in 1968. We don't see the building in 66, but we see it in 78. So it was a very easy application to kind of get through. And this one went through very quickly, but you can see the difference between something like this and something like this. Yeah. So I will encourage you to, so we just recently did a consultation about potential changes to section 36 or the Lands Act. Our What We Heard document was released this week. I would encourage you to go to the Engage NL website and have a read. And basically, the focus was on Lands Act only, but the kind of loud message that was heard is that change is needed. So that's under review to see what that change might actually look like, because we don't want to do something that's going to mess up another process or system. So just to kind of wind down takeaways with MNL and all municipalities specifically, we definitely value our relationship with you guys. We are here in our regional offices. If there's questions, please feel free to pick up the phone. If you need us to come visit you to have a meeting about a file or a number of files, we're certainly available. I hope I've been able to kind of share a little bit of the process and kind of share some of the challenges or limitations that we operate in. And again, just encourage open communication with our regional offices. And there are the web links in case anybody would like to follow up. And like I said, Roger, Trevor, and Jonathan and I are here for the rest of the day. I'm here until about 2, but we'd be happy to have a chat with anybody on the side.